Testing, testing.
I'm going to start the recording.
Okay.
Oh, it's disabled for some reason. Okay, so it is recording on.
Okay. Okay, 1 o'clock. Okay. Ladies and gentlemen, I'll go ahead and call to order this hearing of April 21st, 2022 for, I do have my staff report. We don't have a case number. Oh, there it is. Appeal 22-001, Logan, an appeal about the city's determination of significance for Logan's Landing development. My name is Joe Turner. I'm the city's hearings examiner. I'll start with some brief announcements and a summary of the process that will follow. This is my first in-person hearing that I've had to do in quite a while, like 2.5 years maybe. So if I will try and divert from my usual online introduction to where it's necessary. I start by saying I am not a city employee. I am licensed as an attorney and trained as a planner. I serve under contract to the city council. I say that so you know you're getting a somewhat independent review of the appeal before me today. My role as the hearings examiner is to make decisions about certain land use matters in the city of Woodland. In making those decisions, I'm required to apply the city's existing laws. I don't have the authority to vary from or change the laws. If anyone thinks the laws need to be changed, they can work with Planning Commission and City Council to do that. But state law requires that this application be judged based, or this appeal be judged based on the laws in effect when the application was filed in the appeal. As a hearings examiner, I'm to provide an unbiased decision maker. I believe I am unbiased with regard to this appeal. I have not had any pre-hearing contact with any of the parties regarding the application or the appeal, and I don't have any interest in the subject property or any of the surrounding properties. But everyone has the opportunity to argue that I am biased in one way or another, and you can do that when it's your opportunity to testify. Procedure will follow. I'll start by asking staff to summarize their staff report. I believe copies are available on the table outside the room there. Then the appellant will have an opportunity to present their appeal and respond to the staff report. Then anybody else who wants to testify about this appeal may do so, whether in support, in opposition, or with questions or concerns. Once everyone's had an initial opportunity to testify, I will give staff and the applicant an opportunity to respond to whatever was offered. If those responses include any new evidence, I will give everyone a chance to respond to the new evidence. Otherwise, I'll close the public portion of the hearing and announce what I'm going to do. Generally, I will issue a written decision within about 2 weeks after the close of the record. I'll send my decision to the city, and the city will send it to parties of record. So if you testify orally or in writing before the close of the record, you'll be sure and receive a copy of my decision when it's issued. It is important that all parties make their best case to me. My decisions are now final for purposes of the city, but may be appealed to Superior Court. But generally, the court will not allow new testimony and evidence on appeal. They'll decide the appeal based on the record before me. So if you feel it's important that myself or any future decision maker knows something about this appeal, you must make that decision, make sure that information gets into the record before me. In order to preserve your right to appeal, you or someone expressly representing you must testify orally or in writing before the close of the record. And in order to raise an issue on appeal, someone must have raised that issue before me. If you feel you need more time to prepare, you can ask me to hold the record open or continue the hearing. If I hold the record open, you'll have an opportunity to submit additional written testimony and evidence before I make a decision. If I continue the hearing, we can come back and do this again at a later date. But if anyone wants me to hold the record open or continue the hearing, you must make that request before the close of the hearing today and provide some support for why whatever you want to submit during the open record or continuance, why that information couldn't be submitted during the hearing today. When you testify, please come on up to the podium here. We need to make sure you're on a microphone. This is for people who are present physically in the audience. I understand we have a couple people that online, so I'll get to that in a minute. But for everyone who's present in the meeting, please step up to the podium. We need to make sure you're on a microphone. For everybody, when you start to testify, please begin by stating your name and your full mailing address. Please spell your last name so I get it right. And if you represent someone else, please say so. For those who are appearing online, I think the process is we'll go through the people in the audience first, and then I'll call for testimony from the online participants. You can raise your hand. Is there a raise your hand button on this one? It looks different than my usual computer, so. Yep, there it is. On my screen, it's on the bottom left. I'm assuming it's somewhere on everybody else's. There's just a little hand icon. Click on that. A hand will appear next to your name. We'll go ahead and call for testimony from the online participants using that process.
You can also use the chat. It's the chat options.
Oh, do you use that? Okay. Some jurisdictions disable that just for ease, so it's only one. You can also use the chat function to let us know you want to testify. Nobody appears to be on the phone appearing online, so that's not an issue we have to deal with. So that concludes my introduction. This is the hearing for Logan's Landing, appeal of the SEPA determination, threshold determination appeal 22-001. Mr. Goddard.
Thank you, Mr. Examiner. As you noted, my name is Travis Goddard. I'm the Community Development Director for the City of Woodland, and I am also the city's SEPA responsible official, and I am the one who issued the determination of significance on March 8th, which is document number 29 in the record. So I needed to point out that the city is prepared to issue a withdrawal of the determination of significance.
Okay.
But I didn't do so before this hearing because A, it was a duly advertised hearing, and B, I think I felt there were some issues that we needed to discuss in case this issue does come back to you upon appeal or this appeal proceeds. So I just wanted to have that procedural conversation on the record.
Okay.
So that we had it. Also, in case citizens showed up, that they could give testimony in accordance with regular hearing procedures in case we do a continuance instead of a withdrawal. So the SEPA appeals are generally fall into two categories, procedural and substantive. And the applicant, or the appellant in this case, Ms. Bremer, in her appeal letter, raised essentially the two issues. One was that there were procedural issues, that the issuance was premature, and she also raised some substantive issues about the decision itself. And in my response, the staff report that came to you, I primarily focused on the procedural issues because they were laid out in the letter and attached to the DS. I had a letter which explained kind of the reasoning why I issued it when I did. And she raised some issues that it was premature and that it wasn't based upon a fully complete application. And when she filed her brief for today's meeting, it included the procedural question, but it went on to raise some substantive discussions, and I was not prepared for those. And part of my concern is if you proceed today and you make a decision and the city wants to appeal it, it would go to Superior Court, and it would be based upon the information that was in the record. And because I didn't fully address all of the substantive issues that were in the brief, I wanted to make sure that as part of this discussion, if you're going to make a decision today, that we may need a continuance so that we could prepare a response to get our part of the substantive discussion into the record, because it technically isn't in the record. And that's part of the issue that she made, and that is we were not necessarily making the DS on the full record And so it's a kind of self-fulfilling loop there, and we recognize that. That's why we're willing to have the discussion about the withdrawal. Also, at the same time, if you make a decision and you agree with the city that the decision was procedurally correct, then if they appeal that to Superior Court, then again, the record is not complete because we didn't address those substantive issues. So there are issues associated with that, with the proceeding at this point. Withdrawing the determination of significance would alleviate us both of that issue and the issue about potentially having to appeal it to court to get it adjudicated. So we're willing to address that because there are issues that we wanted to talk about. And part of it is the withdrawal letter essentially recognizes that we would withdraw the DS, and that we would take the project off hold and issue a notice and order. And as part of that notice and order, we would include language that...
A notice and order?
Or sorry, notice of application.
Oh, thank you.
Notice of application, sorry, NOA. The notice of application would include language that the SEPA comment period is running concurrent with the development review, the land use process, and those comment periods would start, at which point we would be issuing the regular DS process, not the optional DNS process, and I'll get into that in a minute. And then that would mean that we would consider all of the comments and the review of the project as submitted before we make the SEPA determination. So typically the SEPA optional DNS process, there's language in the notice of application that says the city expects to issue a determination of significance, and the comment period for that determination of non-significance or mitigated non-significance goes with the notice of application. Therefore, the two processes run concurrent, and when the staff issues a staff report or a decision, that's when the DNS or the MDNS would be final.
And subject to appeal.
Yes, and subject to appeal. So on a type 3, the staff report gives them 2 weeks to file an appeal so that the hearings examiner, who's maybe hearing the conditional use permit, could also hear the appeal at the same hearing.
Mm-hmm.
If it's a type 2, the decision and the SEPA appeal timeline would again run concurrently. So if there's an appeal of one or both of those, then it would go to the examiner, and both would be considered in the single appeal under LUPA.
Okay.
So with that in mind, we wanted to point out that in staff withdrawing the DS, we are not necessarily indicating that there are not issues or there are not impacts that need to be mitigated, or that we don't need additional information. We're just simply indicating that avoiding the appeal process and potentially having to go to court after a continuance, or potentially having a beefed up record for the courts, doesn't make sense. Because as they argued, if it was issued prematurely, whether you make that decision today or whether you determine that, yeah, we could have done it, should we have done it, is a whole nother question, and it may not necessarily be worth that argument. There are dangers for both parties in either way, and that is specifically that we're not recognizing that there may not be impacts that need to be mitigated or significant impacts that need to be addressed. So that is essentially kind of where we are at today. If the appellant feels that that's not reasonable, and I can hand her a copy of the letter that I would make official if she doesn't necessarily have a problem with that.
Okay, yeah, go ahead and do that. And remember, if you want to take a minute to review that, take your time. Thank you.
Good afternoon. For the record, Leanne Bremer, 500 Broadway, Suite 400, Vancouver 98660, representing Logan Partners LLC, the applicant and appellant. So I just need some clarity. I understand the city is prepared to withdraw the DS today. And I've read the letter. What I'm concerned about is that that we'll just be back here again if they decide to issue a DS once the comment period closes. So that we're just really kicking the can down the road. We have an appeal teed up. I was willing to not necessarily waive, but set aside the procedural premature issuance issue so that we can decide today whether a DS is justified. I would be agreeable to not proceeding with the appeal today if we had some assurance that there won't be a DS issued in the future. And I don't know if the city's prepared to do that.
We're going to have microphones over there. I always assumed you did.
Yeah, so there's the microphone.
Okay.
Yeah. So that's why I wanted clarification. I don't know whether I am prepared to say that a DS won't be issued, but I'm willing to go through the review process before we address that issue. Because part of their argument is there's information in the record that may satisfy the concerns that we have, whereas we haven't fully expressed those concerns because the review process hasn't started, which is essentially an acknowledgement of her premature argument. So I can't say that for sure because I haven't routed it to everyone. I haven't routed it to the fire marshal's office of the Viking District, the Department of Transportation. So I can't say, and that's part of the reason why I'm not comfortable proceeding with the appeal hearing given those arguments, because I would have to review the project to rebut the substantive arguments that she's making in order for you to make a decision. And part of that is because what she's asking for you is she's asking you to insert yourself into the seeker responsible role and determine that a DS is not warranted. And I don't know, A, whether you have that authority, or B, whether you're comfortable with that. Because the information that is in the application packet is from the applicant. None of the staff's, none of the review agencies' responses is in the file. So until we go through the appeal, or until we go through the review process, you don't know whether additional information is needed, because neither do I.
Ms. Bremer, if I agreed with your argument that the DS was premature, wouldn't we just end up in exactly where the city wants to be? That I would find it. If I agreed that it was premature, wouldn't we just proceed with the SEPA like the city wants to do now?
Well, there's two parts to our appeal, and the premature and that it's just not justified whether it's issued now or issued in the future. And
Right.
I think you do have the authority and jurisdiction to hear our appeal under the code. It's an appeal of a threshold determination. And so we had two arguments, two bases for our appeal. I think both need to be decided.
Can I decide that the second one, the substantive one, if I find that it's premature?
I think you can on this record, yes. Based on the argument that we submitted, what the application contains, what the city code requires, you can decide that appeal. It doesn't depend on future submittals or comments made by other parties. It's based on the record before you today. You have enough to decide whether DS is justified, whether EIS is necessary.
We're getting into some confusing, some unexplored territory.
Yeah, and I have to say, it's extremely frustrating because
I understand.
it just feels like delay after delay after delay, and we had told the city that it's premature. They went to all the trouble of issuing the DS, provided all the reasons for it. We appealed that. We gave reasons why. The city had plenty of time to come up with arguments on the substantive side of things, didn't, and now it's using that as a reason to, well, we need more time, or just, let's just withdraw and issue it later, perhaps. I can't tell you the level of frustration my client, I'm sure, I'm glad he's not here, but he's traveling, by the way. He would be here if he could. But it's just another example of how we're being treated in this process.
My concern is even if I agreed with, let's see, on the substantive issue, doesn't that cut out the comment period for the public on this DS if I find that the DS wasn't warranted?
No, because what you would do, what your order would be is that the city must withdraw the DS. Then they have to go back and issue a new threshold determination.
Okay.
And then
That's where I was.
Yes, and that would give anybody the chance to comment and appeal that determination, should they choose to.
Which is,
How is that different than?
which is what I'm recognizing. The problem I have is if I agree that a DS isn't warranted, I'm locking myself into either accepting that there are no significant impacts or that the environmental documents discuss adequate mitigation that can be attached to the project. And that may or may not be true. Because, for example, let's pick one that's not relevant. Let's assume that the post office doesn't have enough post office boxes for 400 additional units. I can't just arbitrarily require them to build a new post office because there's nexus and proportionality issues, and I can't say that they need to address that issue. Her point would be that, does that warrant an environmental impact statement? That would be a great point. Not having enough post offices doesn't warrant an EIS, at which point she would have to assume that I'm not going to require an EIS just because of post office boxes. But not having a choice, it means either that they're going to have no post office boxes, or I have to invent mitigation because it's not in the environmental documents.
And Ms. Bremer, I understand your client's frustration, but I don't see what having me review this is going to gain if I agree and withdraw the DS. The city then has to go through the CEPA process. But it seems like having me do it extends it for 2 weeks while I make my decision
Yeah,
versus
I
today.
see what you're saying, because even if they withdraw it today, they can, and even if you say based on today's record that the DS is not justified, are you saying they could still issue a DS?
That's my understanding. And I don't see why they couldn't, because there has to be some opportunity for public involvement in the CEPA process. So I don't want to, it seems to me that it's having me decide it extends everything for 2 weeks versus withdrawing today. Does give you eliminates that delay.
Yeah, and the city is, you're prepared to restart the application review?
Yes, yeah, it says right in there that we would expect to issue a notice of application within the next week, and it'll start the comment period, the public notice.
And I assume there would be the opportunity, if I ruled on this, there would be an appeal opportunity, which might further delay. I don't know.
Yeah, right.
So,
Okay, can I?
yeah, absolutely. If you want to step out, go ahead. Yeah. I'm just going to ask while that's going, does anybody else want to testify today? Yeah, okay. Not yet. I want to make sure everybody's in the room. So I will give you the opportunity. Thank you. For anybody that's online, is this city staff that's online, or could be public?
Tracy is city staff.
Okay. Michelle Corey, is she, we don't know?
I don't.
Okay, assuming Ms. Corey can hear me, if you want to say something about this, having heard what is being discussed, and you don't have to make that decision right now, but if you want to say something, Ms. Corey, you'll need to raise your hand by clicking on the hand icon, and then once the applicant's back in the room and they have the opportunity further discussion. I will open it to public testimony and take anybody's testimony at that point. That's what we'll do. Thank you. This combined online and in person is a little confusing in my first one of these. Sounds like it won't be my last though, because everybody's considering this option.
Am I allowed to say anything?
Is this Miss Corey?
Tracy.
Oh,
This,
Tracy.
this Tracy.
If I assume she can't hear it, but it just cut her off. It just cut you off and
Yeah, I don't know why. you
or
don't have
ended the session, so we'll come back. I doubt that she's hearing me either, though.
yours end too?
Unless it's on the, yeah, mine says you're done and organizers ended the session.
Yeah. I don't want to do that.
Could Tracy see this through YouTube? Is it?
Should be still on YouTube.
Yeah, I'm just talking to, so she knows what's happening. We're trying to fix it in case she's hearing it.
For some reason, it looks like that meeting was set up as a trial.
Because we were testing the microphone, did we set it up as a trial because it was before 1 o'clock? I don't know.
But it would have been set up prior to,
So I'll need to,
Yeah.
I'm not going to do anything yet. Technology's wonderful.
Yeah, I don't know why that is.
Is Tracy a city staff? Can somebody call or send her an email or something?
Yes, Public Works.
Yeah, because I want to make sure she knows what's going on. So that she can get logged back in, too.
is she at the office?
No,
She's at office, so
she's working from the house, and I just texted her.
Okay. Should I log out and log back in then?
Yeah, try that.
All right.
No problem. While you were gone, our session ended, so we got kicked offline.
Oh, okay.
So we've got to fix
We
that.
need to wait for them to come back.
No, we still have to use the official.
Oh, okay.
But Public Works was online and wanted to say something, so I want to get them back. I have to strongly disagree that the meeting was easy to use today. It's not even letting me out unless I comment, so give me just a second. I can't even type. Did I do? This is not my computer, and the keyboard's just off enough that I keep hitting the wrong keys. There we go. Goddard, can you get me back on? Tried to skip all the surveys and
Oh,
I closed the window. Oh. I'm not a PC users. Oh, there we go.
Who knew getting to the web page would be so difficult?
I've got the meeting ID if you want to just log in via that.
No, it's. So I should get you there.
Okay.
Okay, I'm ready.
Travis. Okay, Mike.
Okay, Ms. Coleman, back, good. Ms. Coleman, we're not going to take testimony just yet. The applicant is back, and we're going to deal with that. Let her testify, and then we'll come back to public testimony. Or-
I didn't have any testimony. I just wanted to say that you can't hear because people aren't speaking in their microphones except for you. I can
Okay.
hear you perfectly, but when Travis went up and everybody else and her, it was very hard to hear her testimony. I was only getting bits and pieces, so make sure they speak in their microphone, please.
Thank you, appreciate you letting us know. Is yours on?
Thank you.
It's on,
Okay.
and I can hear myself now.
Yeah, was it on before? Huh.
Maybe I wasn't close enough.
Ms. Coleman, can you hear her now?
Hello?
No, I hear very light female mumbling.
Probably
You can't
just
hear
picking up
precise words.
Okay, thanks. We'll see if we can deal with that. Now we're getting feedback.
Will these microphones work better if we sit here?
Let's find out.
Yeah.
I think it's picking up your computer. Because your
Travis, Travis, I can see you talking, but I can't hear you. So I don't know if there's a speaker that we can put next to him or what.
Can you hear this one? I'm trying a different microphone. I'm
I
assuming.
think it's your computer. Yeah, that's the speaker.
Okay. Can you hear me now, Ms. Coleman?
Yes, I can hear you. I can hear you fine through the whole
Okay.
presentation. Yes.
So it's picking me up through through the computer that's right in front of me. It's not going through the microphone and then into the computer. So give us a second. We're going to try and, I think we're going to try and figure this out.
Is Ms. Coleman the only one on?
Yes.
Oh,
There was one other person, but she's not back, and I'm not sure who it was. It
maybe
looked like
she can
city
run
staff.
down here. Oh. Okay.
So if you could mute your microphone when you're not talking.
This one?
Yeah.
I'm muted now.
Close. Too close.
Can I turn the microphone off? No, we got to have the microphone on. Can we turn off the speakers on this?
Only for whoever's speaking. So, do you stop your microphone?
No, I don't.
Okay, whoever's testifying, just come up to the
So if
computer.
your microphone is off, this one
Yep.
should be fine.
Okay. Can you turn,
Oh, maybe turn it off? Is that-
there's several of them on here.
This will turn off, anyway. Mhm.
No, I think is your computer microphone on?
Yeah, we have to have that on.
That's to order.
too.
You have to pause, so it won't automatically.
Oh, okay.
All the mics appear to be on. I don't know if anybody wants to just testify on the computer, like one up here, everybody can see.
Okay. Okay, it's a little odd.
I know. Do I need to have my mic on so that it's picked up in the recording, or is it YouTube recording?
It's, you read the picture already.
Okay, I had turned it off. Turn that on. Yeah. Okay.
Okay. Coleman, can you hear me? Ms. Coleman?
Yes, I can hear now. Thank you very
Great.
much.
Thank you for letting us know.
Okay, so,
Okay.
Yeah.
well, we feel like we're in this box, and we have no choice but to obviously agree that the city should withdraw the DS.
Okay.
I don't know if that means we need to withdraw our appeal. It could be that we just keep
I
it.
could suspend the appeal.
Suspend the appeal, and let's go through the process of the notice of application. And I would hope that the city would continue to talk to us about the impacts that you feel this project has before you make any determination in the future, so we can avoid resuming the appeal.
Okay. Thank you, Mr. Penner. Okay, ma'am, you wanted to testify, and I'll need you to come up here next to the mic too, so we can hear you.
Carol Browns, 576 Buckeye, P.O. Box 534, Woodland, Washington,
And how do you spell your last name?
Rounds.
Oh, great, thank you. I thought
City Council.
Thank you.
Okay. In this case, I believe the staff, they need more information than what the applicant is giving them, and I trust the staff administrators to administer the code properly. I believe the staff should be relied upon to interpret the code, and I trust the staff to analyze the impacts of the development, and I believe that if they need more information, they do. Commercial property, the prospect purposes is 1% of the land to be used for commercial activities. This is not a token effect to act like a commercial property. Rezone denied. We denied a request to convert this property to residential in 2019. This was a legislative decision that specifically stated this site was not fit for residential development. Zoning impacts, because a use is allowed in a zone does not mean it will not impact the community. The Belmont RV case demonstrated that the neighbors had credible concerns about safety and crime. Economic impacts of not having vital commercial development on commercial properties will have ripples to the neighboring businesses. The council is looking at refining how residential uses could be developed in commercial zones. This project is in conflict with that effort. There is flooding at exit 22 now. It will get worse. Traffic is already bad, and this project will exaggerate that problem. Zoning impacts, because a use is allowed in a zone does not mean it will not impact the community. Size and scope matter. The impact of a residential development are different from commercial uses. This site was never intended for residential development, and the comp plan did not consider it. We just had a finance committee meeting right before our last council meeting. Sales tax from commercial was up 26%. So commercial, once we get rid of our commercial property, you can build a house any place, but once we use up our commercial land, we're not going to have any more of that left unless we can bring more property into the city, and who knows how long that's going to be. So this is going to impact. I'm not opposed to mom and pop operations having a business up above and down below, but renting a parking lot, to me, does not warrant commercial business.
Thank you. Is there anybody else? Yes. Afternoon.
Darlene Johnson, P.O. Box 1808, Woodland, Washington, and Johnson, John-Son.
Thank you.
I was around when we changed the code, and I know that you're interested in interpreting the code as it was intended, and so that's why I came today. A long time ago in the chamber got involved, which I'm really involved in, the Woodland Chamber of Commerce.
Chamber of Commerce, thank you.
Yes, the Woodland Chamber of Commerce. We had like people that had a commercial business and lived up above. And one in particular happened to be the bakery. And they were non-conforming because it wasn't allowed in the commercial zone to live up above. And so we wanted to change that so that people who had a business could actually live above. We may not have written the code exactly the way it should have been written, but our intent, and I can prove this with other people that were, involved in this, our intent was that to allow commercial development in the downtown area and have people able to live up above and not have to have a residence plus the commercial. And since that time, it's been tried to be used by people who want to actually go to areas where we have services and stuff already in for commercial to build residential. It was never intended to be that. In the original, we felt, and we didn't put a footage on it, but we felt that the majority of the building would be commercial. And only a small portion up above would be residential. And I know if you look back at Woodland, we had a lot of mom and pop type businesses. And that's what we intended. And now it's being used in a way that was never intended when we changed the zoning.
Okay. Thank you, Ms. Johnson. Does anybody else want to testify? Okay, seeing none. Is there anyone online who'd like to say anything about this appeal? If so, please raise your hand. Okay, seeing none. Mr. Goddard, anything further from the city? And if so,
Tracy Coleman is raising her hand.
oh, thank you. I didn't see that, Ms. Coleman. Go ahead.
Thank you. Can you hear me okay?
Yes, very, very well.
Okay, wonderful. I am not sure because I didn't hear the very beginning. Did the letter, I met with our city engineer and addressed my concerns with our city engineer and asked him to put together a letter that addressed some of my concerns and in regards to the water treatment plan and the sewer treatment plan that we have in-house. Did that letter get submitted for this hearing?
No, it didn't. But it can be considered, if you did hear what the plan is, that the city tends to withdraw its determination of significance and proceed with the usual SEPA review process and development review process. And so you could submit that during that process if you chose. So
okay, so we don't need to submit that at this time?
Correct.
Okay, thank you very much. I just wanted to make sure that the concerns I had that I expressed were included, and if that needed to be part of this hearing, I wanted to make sure that letter got read into the hearing. But if it doesn't need to make your determination, then I'm fine. Thank you.
Ms. Coleman, you're the Public Works Director, is that what you said?
That is correct.
Okay, just want to make sure I had the right title. Thank you.
Yes.
So technically, those are EIS scoping.
Need to, up here. Does she need to submit it then?
So technically, for the record, those are SEPA EIS scoping comments, and they would no longer be applicable because we're withdrawing the EIS. We will transmit them to the applicants because we'll be starting the review process. So I would even send those as along with the notice of application because they're not technically review comments, they're scoping comments, and in spirit of your request to keep you in the loop of the issues that are being raised, we'll pass those along to your planning team from the beginning. So you may
That worked for you, Ms. Coleman? Yeah, yeah.
But I'll send them to you anyways.
Okay.
For the record.
Yeah. Ms. Coleman, go ahead if you had comment on what he just said.
No, that's fine. I just wanted to make sure that was included. And then to let you also know that we have Cowlitz Public Works that has joined us as well.
Okay.
They also have comments
Okay.
in that same vote.
And Cowlitz Public Works, you want to unmute yourself? What is happening at this point? I assume we had some technical issues, so I'm assuming you didn't hear everything that's going on. But the city has agreed to withdraw its determination of significance and proceed with the usual SEPA process. So without a threshold determination, they'll make their threshold determination after this review of the development and the SEPA and public comment on those. And if then those decisions can be appealed again. But that's where we're at this point. And does Cowlitz Public Works have any comment or want to say anything about that? If you do, you'll need to unmute yourself to do that.
They are saying they are having their own technical issues and
Oh.
cannot.
I can see you now. I haven't seen you in years. Can you? You're good. Okay, thank you. For the record, Cowlitz Public Works gave us a thumbs up. They're good with the process. So, where are Ms. Bremer? Anything you want to add before we?
Well,
Yeah.
I know we're just putting off further review on the SEPA, but I can't let the public comments go without
Mhm.
comment, and just for the record, for a complete
Yeah.
record. Those comments get to the city having second thoughts about allowing residential uses in the commercial zone. And that's certainly appropriate for them to reconsider that and look at their code. This is not the process for that either today or during project review or the next round that we're in. The policy decision has already been made that the code allows residential above commercial in the C2 zone. That's been decided. It's black and white. It's in the code. And this project can be reviewed with that in mind and not be denied because they don't like it.
Okay. Thank you.
Thanks.
So at this point, the city's withdrawing its DNS or its DS. The applicant's agreeing with that, but we're going to suspend rather than withdraw the appeal. Do I need to issue a decision recognizing that, or is this record sufficient? I'm happy to do that. And what happens if the applicant disagrees with the city's final decision? Does this, to my, the suspended appeal? We're definitely plowing some new procedural ground here, so I want to make sure.
I was gonna say, would you lose any ability to appeal later unless you withdraw?
Do I need to?
Yeah,
be on that?
sorry.
Yeah, it is different. I guess when I said suspend the appeal, I think we would have to appeal a new decision that's made.
I think so too. I
Um,
don't know.
So, and it doesn't cost anything. I don't think we paid a filing fee, did we?
You did.
Would the city would refund that and then
Yeah.
or apply it?
The question is if you would withdraw, we would refund, and then there's no question as to whether or not you have a right to
You're right,
reapply.
okay. That's probably cleaner.
Okay.
If we get a refund of the appeal fee, we'd have to appeal again anyway.
That's what I assume. Yeah. So I will. The city has withdrawn its determination of significance. The appellant has withdrawn its appeal. I have no jurisdiction. I don't need to do anything further.
Right.
So that concludes our hearing. What happens now is the city has withdrawn its determination of significance. It will issue notice of the SEPA comment period and the application. Public and agencies will have an opportunity to comment on that. The city will make its new threshold determination and decision on the application. And then those will be subject to appeal by anyone once the city issues those. Do we have a timeline?
I don't.
Okay, that's fine.
So we'll get it noticed and we'll figure out.
Okay.
where to go from there.
So is anybody that's testified going to be a party of record for the future? Can we make sure they're included in the notice in case they're outside the notice boundary?
Yes.
Okay. I think that's the cleanest way to deal with that. So that concludes our hearing. I will not issue a decision in this matter, and we may be coming back, we may not, but we'll see. Thank you all. Have a good afternoon.